In this video, we're going to talk about involuntary hospitalization and some definitions, some process, petitions, and certificate. Now, normally when I do this kind of presentation in class, face-to-face, I basically ask everybody in the class what's the legal criteria for some adult, to be involuntarily hospitalized in Illinois. And invariably someone says clients who are dangerous to self or others. And someone always says that, which is cool, because then it goes on to help me be able to illustrate that common misunderstanding, because that's wrong. Because really it's mental illness plus dangerous to self or others, or unable to take care of basic physical needs. So the main issue here is to be sure about mental illness. Now, when we're talking about someone who's suicidal, it's kind of a moot point, because everybody pretty much assumes if someone's suicidal, they must be mentally ill, at least depressed. And, you could argue maybe it's an adjustment disorder with depressed mood as opposed to major depression. And is that really a mental illness or not? I don't know, but it's in the DSM, so I guess it counts. But actually, there is a definition of mental illness in Illinois, which we'll get to in a few minutes. But I want to talk about children and adolescents just for a second. Pretty much all we're going to be talking about in this video pertains to adults, because there really isn't any involuntary hospitalization for children and adolescents. All admissions are voluntary because the client's parent or guardian has the authority to sign them in, and it's considered a voluntary admission. A young person over the age of 12 has the right to object to the hospitalization. The hospital is, after they're in the hospital is supposed to give them a form and help them do that. From what I understand, talking to people, that doesn't happen all that often. But if they file an objection, it goes to a judge, and then the judge decides whether this young person should stay in the hospital or not. But the criteria are not the adult criteria of mental illness and dangerous to self or dangerous to others or unable to take care of basic physical needs. No, the criteria are emotional disorder and would benefit from hospitalization. So you can see how much broader, way broader that is. Okay, but now we're going to talk about adults, because that's the only real involuntary hospitalization. So I already paraphrased it, mental illness plus dangerous to self or others. Here's the exact wording. You can read this over for yourself on the slide right now. Operant terms here, physical harm or reasonable expectation of being physically harmed, along with mental illness. But there's a second criteria, and this is unable to provide for his or her basic needs, so it has to guard himself or herself from serious harm. Okay, that's the second possibility. Don't forget, mental illness is always a part of it. And then third, there's a fairly new, although fairly new means I think 10 years ago, another legal criteria, which I have it on these next two slides. You can read it over. But basically it means someone for whom we have a clear history. This specific person, we have a clear history of them deteriorating over time and at some point becoming mentally ill and dangerous to self or others, or mentally ill and unable to take care of one's basic physical needs. This number 3 criterion applies when they're starting their deterioration, but they haven't reached the point yet where they're dangerous or unable to care for themselves. And for years, when I was still in Michigan, where the laws are very similar, families would say, oh, we can't put him in a hospital. We have to wait until he tries to kill himself. We have to wait until he tries to hurt somebody else. And it's very frustrating, of course. So at least in Illinois, they passed this new, let's see, new criteria. They were basically, if you can show that the person's going downhill very similar to what they did before, then they can be hospitalized before they reach the point that they're dangerous. That's the third one. Now, mental illness, back here. The definition of mental illness is the following: a mental or emotional disorder that substantially impairs a person's thought, perception of reality, emotional process, judgment, behavior, or ability to cope with the ordinary demands of life, but does not include a developmental disability, dementia, or Alzheimer's disease, absent psychosis. Some people with dementia or Alzheimer's, Alzheimer's being one type of dementia out of maybe 20. I'm not sure why they separated it out here, except it's just, I think, more well known to most people. But people with dementia can get psychotic, in which case they would be considered mental illness. But if they just have dementia, under Illinois law, that's not considered mental illness. Another exclusion is a substance abuse disorder, and another exclusion is an abnormality manifested only by repeated criminal or otherwise antisocial conduct. In other words, antisocial personality disorder. So this definition of mental illness and these particular exclusions really highlight the importance of the presence of mental illness. As I said, it's kind of taken for granted when someone is potentially suicidal, but it becomes much more important when the danger is dangerous to others, where someone's potentially violent toward others, because there's many people who are potentially violent but who are not mentally ill, and many of them would be considered to have an abnormality manifested only by repeated criminal or otherwise antisocial conduct. So those non-mentally ill, dangerous people are not subject to involuntary hospitalization. Or, I don't know, how many violent people are in Cook County Jail and not in psychiatric hospitals? Mainly, well, for many reasons, but, one main reason is there's no treatment for antisocial personality disorder. There's certainly no short-term inpatient treatment for antisocial personality disorder. Hospitals don't want those people. They would have nothing to offer, no way to help. And this gets reflected in the law in this way. So the mental illness is important when we talk about danger to others. So if someone's dangerous to others because of mania, the psychosis from schizophrenia, things like that, then there's no problem. But mental illness must be present. Okay, so the process of involuntary hospitalization involves two legal forms, a petition and a certificate. The petition is the one that any layperson, typically a family member, ideally, but really anybody over 18 can fill it out who has observed the dangerous behavior, the suicidal threats or the suicidal behavior, the danger to others, whatever it might be. The petition, and it focuses on the dangerous behavior. A certificate is filled out by a professional. There's actually two of them in the process. The first certificate can be completed by any physician, any psychologist, or any qualified examiner. And in turn, a qualified examiner, there's like 3 or 4 different professionals who would count as a qualified examiner, and an LCSW, right? So that's 2 years after you graduate. If you get the requisite number of supervised hours, you can become an LCSW. And if you're an LCSW who normally works for mentally ill people, then you're a qualified examiner. There isn't any, it's not like you write to the state and get a license or a certificate or anything like that. You just say, basically, I meet this criteria, therefore I am a qualified examiner. If you're a school social worker, on the other hand, you'd be hard-pressed to say that you're a qualified examiner. But if you work in a psychiatric hospital, you work in an outpatient mental health clinic, a family service agency, things like that, then you too could be a qualified examiner. The second certificate, which is done after the patient is hospitalized, must be done by a psychiatrist. And in both cases, the certificate is mostly focused on the mental illness. There's no requirement that the person filling out the certificate has been an eyewitness to the violent or dangerous behavior, which is pretty much a requirement for the person filling out the petition. So the petition focuses on the dangerousness, the certificate focuses on the mental illness. So I'm going to walk you through a simple example here. Here's a guy named Bob. Let's say Bob is 21 years old, lives at home with his parents in that home, and Bob is depressed, and Bob has become suicidal, and on a given occasion his father walks down into the basement of the house and finds Bob loading the family shotgun and talking about suicide. Okay, pretty scary. So at that point, Bob is then brought by his parents to a hospital and to the emergency room. And when I used to work in the ER, we would frequently get calls of a similar nature, and our direction was, bring him to the ER. Sometimes they would say, well, he won't come. And our answer was, well, make him come. Families can do things that no one else can do. Families can kidnap their own family members. Family members can force people, Call up your two big cousins who live out on a farm, have them come and strong arm Bob into the ER. And it sounds like a joke, but I certainly have recommended that, and I know lots of cases where that was done. And I think it's the correct thing to do. Get Bob to the ER. So Bob comes to the ER. He's seen in the ER, and let's say we have a social worker who interviews Bob and his family, and the social worker then says meets with them separately and says to the family, well, I met with Bob, and I certainly agree with you that he's depressed, and I certainly believe what you said, Mr. Smith, that you caught him trying to load the shotgun, that he's potentially suicidal. But when I tried to get him to sign into the hospital, he refused. And so Bob's parents say, well, but he's dangerous. Can't you just put him in the hospital anyway, whether he gives consent or not? And you, the social worker, say, well, we can, but we need your help to do this. You're the one, Mr. Smith, who observed the dangerous behavior, and so we need to have your legal testimony. We need to have your assistance to do this, and there's a legal form to fill out. And Mr. Smith goes, I don't know, I'm not sure I want to do that, and blah, blah, blah. But you convince him that this is the only way, and you give him a copy of the petition. So the petition I've now put up on the screen here, and I've posted this in Sakai, a blank form, and I've also posted in Sakai this one that I've used as an example, filled in some of the check boxes and the completion lines, just to give you an idea how to do it. And this part's pretty straightforward. The kind of situation we're talking about is the first of these check boxes, emergency inpatient admission by certificate. Okay. Over on page 2, then the person filling out the form puts the name of the client, and then here's some check boxes that exactly reflect those definitions of mental illness I told you about a few minutes ago. The first one is mental illness plus dangers to self or others. The second one is mental illness and inability to take care of basic physical needs. The third one is the deterioration criteria. You can check 1, 2, or 3. Well, 1 or 2, or the third one. If you got 1 or 2, you don't need the third one. And then the fifth one, which basically says in need of immediate hospitalization for the prevention of such harm. They could have built that into the earlier ones. I'm not quite sure they didn't. But you can see on the example here on the PowerPoint, and you can also see this in the document that I posted in Sakai. Further on down on page 2, there's a checkbox where the person filling this out says, I base the foregoing assertion on the following. And they're supposed to fill in this box a very brief description of what something about mental illness, but primarily what the dangerous behavior is in very basic terms. So in this example that I just have posed for you, I would ask Mr. Smith to fill it out, and he would write something like, my son Bob has been depressed for the last several weeks, and last night, put the date in, last night, what date is today that I'm making this video, October 12th. So last night, October 11th, 2020, I caught him loading a shotgun in our basement. He had been talking about suicide on and off for the past several days. You know, right? Something very simple like that. The next checkbox, or the next box to fill in, is are there any other witnesses to the dangerous behavior? And especially if the person filling this out is not a family member, then they would like to get the family members there. And then, of course, in the very next box, they're explicitly asking for the names and contact information for family members. You can see there's a couple other checkboxes here. I'm going to skip over them. They don't come up that often. And then when the person completes this petition, typically they then, the client is also interviewed by a physician, a psychologist, or a qualified examiner who fills out the first certificate, which is a checkbox here. One certificate of examination is attached or accompanies this. Further on down on the third page, if the police are involved, then the mental health, the Division of Mental Health wants to know who they are, officer's name, which police department, because so often police bring mentally ill and or dangerous people to hospital emergency rooms, and then they drop them off and they take off. They may give a little description of what's happening to the triage nurse, but often they drop them off and take off. And so this is a way to remind the people in the ER or in a receiving hospital to get the names of those police officers. And in fact, when the police bring someone in because they've observed dangerous behavior, they're supposed to be the ones to fill out the petition. The families at home, they may not have seen what's going on. And then finally down below, there's a place, the date, the time, the person filling it out, their signature, their printed name, who they are in relationship to the respondent. The respondent is the client, telephone number, contact information. Now I can tell you, having done this many times in an emergency room setting, if you interviewed the client, you interviewed the family, or maybe another social worker or another clinician in your ER interviewed the client and you interviewed the family, and you explain the process that they need to be involved by filling out this petition, and you give them a petition, you give them a clipboard with the petition on it and a pen that writes, and you walk away and you come back 10 or 15 minutes later and they haven't done a thing. Because it's intimidating, right? It's a legal form. People aren't sure they're going to do it the right way. It's intimidating. And so I highly recommend that what you do, and what I did many times, is you hear the story and then you say, well, how about Mr. Smith, I'll fill this out and I'll try to use your words, and then you can read it over, and if I've reproduced what you have said correctly, then you can sign it, and we'll go from there. And people always want that. So you have to listen carefully and be able to paraphrase or quote what they said. But it always works a lot better, and it's much quicker than trying to coach family through this intimidating form. All right, so now we have the petition. Now we need the certificate. So the petition that we just saw, by the way, is 5 pages. I just showed you the first 3. But again, the full document is posted on Sakai for today. The last 2 pages are kind of boilerplate things that there's little need to look at in the ER. It's patient rights and documents that are given to the person after they're in the inpatient unit. But we're still in the ER, and we now have the petition, and now we have to have somebody, a physician, a psychologist, or a qualified examiner complete the certificate, which is just 1 page. You can see I put it up on the PowerPoint right here. Usually in a hospital ER, they want the emergency room physician to do it, but it varies by hospital. So here's the document, and there's a very interesting thing here. Right at the top, right below the client's name, there's a statement. And the examiner, the psychologist, the physician, the qualified examiner, is supposed to sign right at the top that they read or paraphrased this statement. And you can see it right there. I personally informed the above named individual of the purpose of this examination, and that he or she did not have to speak to me, and that any statements might be related in court as to the individual's clinical condition and need for services. And the rest of it's not quite relevant. Now, the person filling out the certificate is supposed to do a formal interview with the client and read or paraphrase that statement to them. And I have to tell you, it hardly ever happens. And the reason it doesn't happen is it's a Miranda warning, basically, right? You have the right to remain silent. You have the right to have an attorney appointed for you, blah, blah, blah. In this case, I informed them of the purpose of this examination, and that he or she did not have to speak to me, and anything they used may be used in court. Not as a legal, not because they've done anything illegal, but used in court to determine whether they need to be in the hospital or not. And so because of the fear that the client won't talk any further, the vast majority of doctors and others who fill out this form don't actually do that. Now, most of the time, it just slides by. Nobody said anything. I did indirectly hear of one case that went to court, and when the client goes to court, an attorney is assigned from the public defender, and the public defender questioned the person filling out the certificate about whether they read that statement, and when they said no, the whole thing got thrown out. Okay, so there it is. You're supposed to do it. Hardly anybody does it, and hardly ever is it really brought to anybody's attention. Most of the time, because the judge or the attorneys, if it goes to court, even the defense attorney mostly think, oh, this person needs to be in the hospital, and so they perform what you might call a perfunctory defense. So further on down, the date, the time, the location, and then once again, right in the middle of this form, you see the same exact definitions of mental illness plus dangerous to others, and or mental illness plus unable to take care of basic physical needs, or the deterioration criteria, and in need of immediate hospitalization. Exactly the same as what we saw on the petition. And then there's a space about 2/3 of the way down where the person completing this is supposed to summarize the signs and symptoms of mental illness that they saw in the interview. They're not supposed to just rely on past diagnosis, but actually elicit some of the signs and symptoms in the interview to basically demonstrate that the mental illness is current, it's in the present. And they're not required to really say much about the dangerousness since they really didn't observe it, but oftentimes people say that given the mental illness, the description that they heard about dangerousness makes sense. It seems reasonable. And then you can see the check boxes and where they complete it at the bottom. Okay, so that's the certificate. And that also, a first certificate would be completed in the ER, again by any physician, any psychologist, or any qualified examiner. And then once that is completed in the ER, then Bob can be hospitalized. So you can see in my little diagram here that Bob goes from the ER to the inpatient psych unit with one petition and one certificate. Once Bob arrives in the psych unit, then within 24 hours, there has to be another examination for a second certificate, and as I mentioned earlier, this second certificate has to be filled out by a psychiatrist, and it's typically a psychiatrist that works on the inpatient unit where Bob has now been hospitalized. So there's Bob. He's in the unit. Now what happens if you go to an ER and they don't have a psych unit or they don't have any beds? I hope I didn't just blur myself there. What if there's no beds or no unit? Then with the petition and the certificate, an ambulance can be called and Bob can be taken to some other hospital or to a state facility with a petition and one certificate. And then again, he would be evaluated. Again, every hospital, of course, wants to do their own evaluation at this other hospital or at the state facility in order to complete the second certificate. I wanted to mention something else I guess I kind of glossed over. There's another, in that situation where the police sometimes just drop somebody off, which would look, back would be more like this one. Whoops, would be more Bob is in the ER, but only the police have brought him in this case, but the police drop him off and leave, then there's nobody who's observed the dangerous behavior, and sometimes the ER social worker is stuck filling out the petition, but on the basis of no direct knowledge of the dangerousness. And again, the petition is supposed to be filled out by anybody over 18, but the person is supposed to have eyewitnessed the dangerous behavior. So a ER social worker can only go by, like the triage nurse tells the social worker that the police officer said, we found Bob walking down the middle of the street on a busy street and he almost got hit by a car and we think he's dangerous to himself and goodbye. So the triage nurse writes that down and tells the ER social worker, and the ER social worker winds up filling out the petition on the basis of hearsay, which is supposed to be illegal. They don't have the police officer's name, so they can't call him or her back to fill out the petition. And so this shouldn't technically be legal, but it happens all the time. And again, because at this point, if a person's gotten through all these checks and balances, these checkpoints, most of the time they really do need to be in the hospital. And so pretty much everybody involved in the process doesn't object very much, except Bob, of course. But okay, so anyway, Bob is either in the psych unit at the first hospital, or he was then transported to another hospital where he was admitted. Okay. Now, what if before Bob's parents and his two big cousins can bring him to the ER, what if Bob just runs away and now he's just out, who knows where, out on the street, and his parents are really concerned, but they can't get a hold of him to bring him to a hospital ER? What are they going to do? Well, what they can do is go to a state's attorney's office, either in the city or in the county. And at the state's attorney's office, they explain to one of the state's attorneys what the situation is, and they fill out a petition, the same petition we've been talking about. Now, Bob's not there, so there's no way anybody can examine him or interview him to fill out a certificate. So on basis of the petition only, the state's attorney takes it to a judge, and if the judge thinks it seems reasonable and the family or whoever filled it out seems reputable, then the judge will issue what's called a writ of detention. Now, the writ of detention really basically empowers the police to pick up Bob whether they themselves observe any dangerous behavior or not. The writ of detention is actually given back to the family, and then the family has to take it to whichever police department covers the area where they think Bob is. And then the police, if they find Bob out there on the street, then they can pick him up without observing any dangerous behavior and take him to either a state facility, or there's a handful of hospitals in the city which have been designated for police to take people they think are mentally ill and or dangerous. Now, the police don't want to do this, and they won't really, put a lot of resources into looking for Bob, but if they find Bob and they have the writ of detention, they'll pick him up and take him to a hospital to be evaluated. The other option would be Bob runs away and the parents don't go to the state's attorney's office, but Bob is out in the street, like my earlier example, walking in traffic, almost got hit by a car. The police who directly observe the dangerous behavior can then pick up Bob, bring him to a hospital, like I said, either a state facility or one of the handful of city hospitals that are designated for that. And again, they're supposed to fill out the petition, and then Bob can be evaluated and hospitalized in that way. Okay, so a number of different routes this could happen. Now, Bob's in the hospital. Once he's in the hospital, assuming the second certificate is completed, he is given an option to sign in voluntarily on a document called a formal voluntary agreement. And a formal voluntary basically says that Bob is agreeing to come into the hospital, and in order to avoid the dilemma of someone, the patient agrees to sign into the hospital and then it turns around because they're now voluntary and signs out again 20 minutes later. In order to avoid that, the formal voluntary basically is an agreement, is a contract, if you want to call it that, where the client or patient signs into the hospital and they agree that the hospital has a right to hold them. And then if they want to leave, they have to request a form, a request to leave, something like that, and then the hospital can keep them for up to 5 days before they're discharged. And during that 5 days, then they have the option to institute, to fill out a new petition, to fill out a new certificate, basically reinstitute the involuntary process if they feel the need. So the client signs a formal voluntary, and that keeps them in the hospital. Or if the client refuses to sign a formal voluntary, or they do and then they try to leave and the hospital reinstitutes the involuntary, in either case there is a court hearing that happens within a week. Now the emphasis is on getting people to switch to a voluntary to avoid the court. To take a client to court takes 2 people from the hospital. It takes a doctor away from the inpatient unit. It's a big hassle. And so the emphasis is really on getting people to sign a voluntary. In Michigan, when I worked there, it was the other way around. They would basically keep people on an involuntary just to kind of have more control. But then in many cases, there was a courtroom set up in the hospital, in the state facilities where most of the involuntary patients went. And the judge and the lawyers and everybody came to the hospital. So it wasn't such a big drain on the hospital resources, the doctor's time, and things like that. If the court hearing happens, the person filling out the petition has to attend, and the psychiatrist who did the second certificate has to attend, and they basically briefly testify under oath, pretty much repeating whatever they wrote on the documents, and then the judge decides whether the client meets the criteria, mentally ill and dangerous to self or others, mentally ill and unable to take care of basic physical needs, or whatever. The judge decides, and if so, then typically there's a 60-day court order. Now, the patient or client could be discharged from the hospital before the 60-day court order is up. That is, the psychiatrist in charge of the case has the authority to discharge Bob at any point in between if Bob is ready to go. But ultimately, if not, then he can be held for up to 60 days, and then another hearing has to take place. All right, so this is the process of involuntary hospitalization for adults in Illinois. And again, the documents which I've included in the PowerPoint here, I've also posted on Sakai, both the petition and the certificate, a blank example, and then a petition and a certificate as I've shown you here on the PowerPoint of examples of how to fill it out. Okay? Okay, I'll see you next time.